I just wanted to say welcome to the 2023 Watershed Congress. My name is Byron Riggins. I'm the Restoration and Advocacy Coordinator here at the Delaware Riverkeeper Network. I'm also your moderator for today's session, Tax or Fee, Borough of West Chester versus Pennsylvania State System of Higher Education. And we are pleased to present our speaker for this session. I'm going to turn it over to our speaker, Mark Alfred, to introduce himself. Thank you.
Hi, everybody. It's a pleasure to be here today. I'm looking forward to talking about this topic. I understand and I see that we have some folks on here that are lawyers, some folks that are non-lawyers. So I'm going to try and get into some of the nuances without hopefully getting too far into the weeds. Let me start out by just introducing myself. I am an attorney. I have been practicing for over 30 years in both environmental and municipal law. I am a township supervisor and a solicitor to a number of municipalities. I also worked for the state for 10 years, 8 years as a counsel with the Department of Environmental Protection, and was at one point the Department of Environmental Resources, and then also a couple of years as an environmental crimes prosecutor with the Attorney General's office. So what we're really here to discuss today is the case that was handed down by the Commonwealth Court on January 3rd, 2023, related to the West Chester Borough stormwater charge, I'll call it, because obviously they ruled it was a tax. I think the borough believed it was a fee, and we'll talk a little bit about what that means and why that's important. Just before we delve too deep into it, it's probably worth noting that the Commonwealth Court is in Pennsylvania what they call an intermediate appellate court. So generally you have a trial court, an appellate, an intermediate appellate court, and then the highest appellate court in the state system, which is the Pennsylvania Supreme Court. There's two intermediate appellate courts in Pennsylvania. One is Commonwealth Court that deals with appeals related to government entities, and then the other is Superior Court, which deals with all the other type of things. So this is a decision out of the intermediate appellate court, and it may ultimately the Supreme Court may look at the issue differently. Frankly, I've tried to determine if this has been appealed. I could not tell anything from the dockets. Didn't tend to reach out ahead of this, didn't have a chance to talk to the counsel. Some of the counsel I know were involved in the case to see if it was appealed. I had expected it to be appealed, although have not seen it. But in any event, eventually the issue could ultimately, either in this case or another case, get up to the Supreme Court of Pennsylvania that may look at it differently. So what is the stormwater fee? So the borough had created this charge to deal with the various expenses associated with a growing problem in municipalities throughout the Commonwealth, which is how to manage stormwater, both what's known as the MS4 program, which is a federal and state mandated program that deals primarily with water quality in our area, in the Southeast Pennsylvania area. The main pollutant that's looked at is sediment. Some other types of pollutants that are often looked at are nutrients, particularly in the Chesapeake Bay area. And then there's also the whole flooding water quantity issue. That's a big issue, and that municipalities are struggling with how to deal with what appears to be growing rain events and impacts from water, and how they're going to deal with that and how they're going to pay for it. So West Chester Borough came up with a fee that was based primarily on the amount of impervious surface. That's the surface that does not allow the water to absorb into the ground, as opposed to a grass field. It's the biggest example would be a concrete or parking lot area, an asphalt parking lot area. So Commonwealth Court ruled that West Chester Borough's stormwater charge that they set up as to help pay for this type of work constitutes a tax and not a fee, and that and in this particular case, the challenge was brought by the state system of higher education at West Chester University, who are immune from paying taxes, and they essentially said, we don't really care what you do with other people, but we're tax exempt. This is a tax. We don't have to pay it. The borough had enacted the ordinance that imposed the purported stormwater fee on owners of what they call developed properties. And as mentioned, the developed properties are generally those properties that have at least significant amounts or some amounts of impervious surface. The borough designated the charge as a fee rather than a tax, which was important so that it could capture tax exempt entities like the university and the higher education system, and which, particularly in West Chester, I believe the recent decision indicated that the university has about 8% or so of the impervious surface in the borough. So it was important from the borough's perspective to try and capture those tax exempt entities and make sure, in their opinion, at least, that they were paying their fair share. Now, based on the findings of in the ordinance and as reported in the decision, it appears that the borough is focused on the harm that a particular property caused related to stormwater as a result of development and impervious surface. Again, the more impervious surface a property has, the more impact I believe the borough thought you might have, and so they charged a fee based on the amount of impervious surface. The more impervious surface, the bigger the fee. And the borough argued that the ordinance provided the payors, the people who were being charged the fee, with certain benefits, essentially that their stormwater would be treated and handled by the municipality through the various improvements that would be made from the fee. Now, in finding that the charge was a tax rather than a fee, the Commonwealth Court really did not look at the harms caused by the property, and instead they looked at the benefits that the property owner received. And this is part of what we're going to jump into a little bit, is the way that the Commonwealth Court looked at this and why they got to the result they got to. One of the things the court noted is that although the borough had, asserted that the payors, the people to whom the fee was charged, were getting certain benefits, they really did not present evidence of discrete benefits through the payment of the charge. And the court noted that the borough did not maintain a precise calculation of the volume of stormwater from the school, so that no direct measure of the payors' purported use of stormwater system existed. The court also found that impervious surface area of the property did not necessarily correlate to the level of benefit received by the owner. So again, the court's focus was really on what benefits are the owner getting. Are they getting benefits? Are they getting discrete benefits, or is this some sort of general benefit? And the court concluded that the flood control is essentially a broad public benefit, and that charges that have that kind of broad public benefit are generally viewed as a tax and not a fee. The court did go into other parts of the analysis. They addressed whether the charge is a general tax or a special assessment. I don't know that we need to talk about that, because under either scenario, the charge would be considered a tax to which the school and the higher education system would be exempt. The court found that it was just to mention, the court found that it was a general tax as opposed to a special assessment. So what does this all mean? Is this the end of tax exempt entities paying for stormwater in municipalities? I think to understand that, we need to take a little bit of a deeper dive. And I will emphasize that the issue is not whether a local municipality can impose a stormwater charge. It's really the issue is who has to pay. You know, are tax exempt entities like the school, like the higher education system exempt or not? So initially, you know, and this is where we start to get a little wonky, and I'll, like I said, I'll try and keep it at a high level. And part of, you know, but you do need to understand the context. I think you do need to understand some of the applicable laws, what laws applied, what laws didn't apply, and what laws may apply to other types of entities. So one of the things that the court noted is that in its decision, particularly at the end of the decision when it was concluding, is that its decision is based on the applicable laws that were at issue in the case. And it made a point of saying, absent an explicit statutory authority, property owners in the Commonwealth, you know, that are tax exempt or immune from taxation and don't need to pay this charge. West Chester Borough is a borough organized under the Home Rule Charter, and the court did make a specific note of that. And just generally, generally, when you're dealing with home rules in Pennsylvania, what the home rule does is allows a municipality to sort of create its own rules of how it's governed, but there's often gaps in those rules. And when the home rule charter does not address a specific issue, the issue may be governed by the generic code that would have applied to that particular entity. In this case, because we're dealing with a borough, that would be the Pennsylvania Borough Code. It's to what I noted, and this is a lot of this is my opinion, because we're sort of in a guessing, we're sort of in a little bit of a guessing game now, because we don't really know how it's going to play out in different situations, on appeals, on under other types of scenarios. But the Home Rule Charter does not address stormwater management activities, and the Borough Code does address stormwater management activities, but only very generally. What the Borough Code provides is that a borough may acquire, operate, and maintain areas for infiltration, detention, or retention of stormwater, and for other methods of stormwater management authorized by the Department of Environmental Protection. But the Borough Code does not address how the borough can or should charge for that service. And there was not law at issue in this case that directly addressed the kind of charge the borough could impose. So that's part of, I think, what Commonwealth Court was struggling with is, while under the Borough Code there can be these types of improvements that the borough makes, it doesn't really get into how that's charged, how its rates are supposed to be, if you call it a rate, how it's supposed to be set up. Now, I think it's important to note that there are a couple other laws that govern other types of entities that do provide more specificity. And that's, I think, to my mind, one of the big questions is, how are these going to be dealt with? How is a similar situation going to be dealt with by other types of entities, by courts dealing with other types of entities? So, for instance, there's something, you know, in addition to municipalities can establish authorities that are governed by what's known as the Municipality Authorities Act of 1945. That's the actual specific name. In 2013, there was an amendment to the Municipalities Authorities Act that said that an authority that can be set up to perform stormwater planning, management, and implementation, and such an authority can charge, and this is the language from the amendments, reasonable and uniform rates may be based in whole or in part on property characteristics. And so there is specific language about, in the Municipalities Authorities Act, about charging rates based on property characteristics. There's actually, and the vast majority of municipalities in Pennsylvania are actually second-class townships. And they're governed by the second-class township code. And the second-class township code actually has even more specific language about the way that a second-class township that handles the stormwater management itself and doesn't create an authority to handle it, can set up and charge for these types of improvements. Like the Municipality Authorities Act, the second-class township code says that the township may assess reasonable uniform fees based in whole or in part on the characteristics of the property benefited by the facilities. And then it goes on further to say that any fee levied by a township can be assessed in one of the following methods: on all properties in the township, on all properties benefited by a specific stormwater project, or by establishing a stormwater management district and assessing a fee on all properties in that district. Now, I will note that while this puts more meat on the bone with regard to the type of charge or fee that can be charged by either a second-class township or a municipal authority, it still doesn't get to the core issue necessarily as to whether or not this is a tax and a fee. I think you could, based on this language, make arguments, and I'm sure arguments will be made either way on how this should be looked at. I also think it's important not to look at the Commonwealth Court decision in a vacuum. The Commonwealth Court actually based a lot of its decision on a federal case known as DeKalb County versus United States. And that which came out of Georgia. And that case actually, talked about a much bigger sort of system in which this should be looked at. There's another important case that I want to talk about too, that found sort of the opposite of DeKalb County, which found it was a tax. It was a case out of Virginia in 2019 called Norfolk Southern versus City of Roanoke that looked at a similar issue and found that in that case, the charge was actually a fee and not a tax. And both the DeKalb case and the Norfolk Southern case applied what's known as the San Juan cellular factors. And I only want to go through this briefly because the Commonwealth Court relied on this, but didn't really express sort of how they were getting these elements and where they came from, and how this all fit in. So under the DeKalb County or the San Juan cellular factors, there's really three aspects that the court looks at: what entity imposes the charge, what population is subject to the charge, and what purposes are served by the use of monies obtained by the charge. There's other factors that the courts look at, such as the non-consensual nature of a charge, things like that. But the three elements I just mentioned are essentially the elements that courts, the federal courts and now in Pennsylvania, seem to be looking at when determining if something is a fee or a charge. And one thing that the Norfolk Southern case specifically said, and DeKalb also alluded to, is in the close case. And I think I would call what the West Chester case, the Commonwealth Court decided a close case. The what purposes are served by the use of the money is really going to be the main, most important factor. So I think looking at these elements and knowing sort of where the Commonwealth Court got its analysis from, I think helps shed light on what the Commonwealth Court did and why. So, as mentioned, the DeKalb case, and as mentioned at length in the Commonwealth Court's decision, the DeKalb case found that the charge was a tax and not a fee. In contrast to the Norfolk Southern case out of Virginia, said that, I'm sorry, the DeKalb case said it was a tax. The Norfolk Southern case said the stormwater charge was a fee. And in addressing the question of what purpose the charge served, the court didn't focus the way the Commonwealth Court did or the way the the DeKalb case did on sort of the benefits to the property owner, it looked more, it did look at somewhat at the harms, but it also looked at the charge that was being charged as part of a larger state and federal comprehensive scheme to address stormwater, including the MS4 program. And as I mentioned at the beginning of my comments, municipalities in Pennsylvania are struggling to deal with the requirements of MS4, which is the way in which municipalities have to deal with their stormwater. And these are very, very expensive. I can tell you in the township where I'm a supervisor, I mean, we're spending millions of dollars to implement MS4, and some people have characterized MS4 program as an unfunded federal and state mandate. So it really is part of a bigger statutory scheme that comes out ultimately out of the Federal Clean Water Act. And what the court in Norfolk Southern said was, well, look, what the municipality, in that case, a county, I believe, in Norfolk Southern case is trying to do is come up with a way of paying for this requirement that's part of this larger federal and state regulatory scheme. And therefore, they felt that it was fitting into this because it was fitting into the scheme and because it was providing benefits associated with the scheme and also trying to mitigate the harms created by impervious surface. They viewed it as a fee. And the court also looked at the harms in the ordinance that the fee was trying to prevent, as I mentioned, rather than just merely the benefits. What's really kind of fascinating to me is that there really was another Commonwealth Court decision in 2020, a few years ago, that looked at, it's called the Appeal of Best Homes case. And it was looking at a situation where the city of Chester in Delaware County, their stormwater authority had imposed a charge. And in that case, the Commonwealth Court, and again, both of these Commonwealth Court decisions were what we call en banc decisions. They were decisions that were by, normally on an appellate review, you're going to get three judges from the court hearing and making a decision. But if it's an important enough issue, it can go en banc where the whole court hears it and the whole court can participate in the decision. In the city of Chester case, they actually found that the charge was a fee and not a tax. There are a number of differences between the West Chester case and the Best Homes, Chester, city of Chester case. First, the city of Chester was an authority, not a borough. And as we talked about, the authority does have different language. The court didn't really get into that, so it's not clear if that's had a major impact or any impact on their decision, but it's one of the things that I noted. And there's another issue, and this is going to get very wonky, but I'll just mention it quickly. There was a different burden in the two cases between the Best Homes case and the West Chester Borough case. In the Best Homes case, the court noted that Best Homes, which was the property owner, had the burden to show that the authority's fees were revenue raising. They essentially had the burden to show that the authority's fees were taxes, not fees. Whereas in the West Chester case, the court said that the borough, and this is just based on the way that the cases were set up and what was at issue, that the borough actually had the burden of showing that the school was not immune from paying the charge and ultimately whether or not it was a tax. So in both cases, they said whoever had the burden didn't meet their burden. In the West Chester case, the borough failed to meet its burden. In the Best Homes case, Best Homes failed to meet its burden. But what you see is you got two different results in the case, one of it being a fee, one of it being a tax. So I found that interesting. I don't know if that's ultimately what swayed the courts. But so there's a lot of, and I think that the outcome of this. So there's going to be a lot of unanswered questions. So ultimately, what we have to do is ask ourselves, what does this all mean? How does this all shake out? And again, time will tell. Time will tell. Perhaps Commonwealth Court decision will be reversed either by a subsequent decision or subsequent Supreme Court decision, or if there is an appeal. The time to appeal has already passed, and as I mentioned, I wasn't able to ascertain whether appeal's been filed at this point. Perhaps the courts will find that the fees enacted under different local government authorities that we talked about, the second-class township code, the Municipalities Authorities Act, the first-class township code, other types of authorizing statutes, whether they're more defensible, whether a different set of facts might prompt a different result. Maybe, if in the next case, if a municipality is able to show that it's, what the actual benefits are, as opposed to the West Chester case where the court found the borough really didn't show what the benefits were to meet the test that they set up. Again, the test being Commonwealth Court test being really primarily to focus on the benefits. Perhaps the General Assembly, the state legislature, is going to jump in with some clarifying language. This is all still very up in the air, so I don't know that we, have answers to a lot of this, but what I wanted to do is at least try and lay out some of the framework, as I see it, at least from looking at some of the cases, and laying out what the court seems to have done. So that's really my comments on this. I can go into more detail. I don't know if people have specific questions that they'd like answered. I'm happy to address any questions or talk a little bit more about what the cases, what the Commonwealth Court decision and some of the federal cases I discussed actually said.
Wonderful. Well, thank you, Mark, for your presentation. We do have questions from the audience. So the first one is kind of long, so bear with me here. Says, thinking about who benefits from charge money collected or charge/money collected, how would this Commonwealth decision cross over and affect Commonwealth municipalities with sanitary sewer fees, mostly through authorities? ? Many municipal authorities enact and charge residents sewer fees, which do projects that benefit only small percentage of their population, and many dollars spent may never benefit large portions of the local residents or property owners. If we look at an overall benefit or localized benefit, is there any concern that this decision could have ripple impacts to have sanitary sewer fees now be considered taxes versus fees? Because money collected is used for community benefit and not assessed to those directly benefited from capital or operational expenditures.
So I think there's a lot in that question. The one premise I think I'll start out with is saying my experience, and maybe there's other situations. My experience is that sewer fees are not used by the general fund. Sewer fees generally go into a sewer fund that are used for improvements of the sewer system. That's how they're handled in the municipalities that where I'm a supervisor and in the municipalities that I work with. So there's also specific language on charging fees for sewer in some of the statutes. So I think it's a little bit, again, I don't want to get too wonky, but you're getting into a little bit of a different scenario because you're dealing with potentially some specific language. This is just off the top of my head. I don't see it as sort of crossing over in the sense that sewer fees, and again, it gets, and this is some of the language in the cases that I did find a little bit troubling and problematic, where they started getting into, is it consensual? Is it, is it contractual? Because in sewer fees, obviously, you don't really have a choice if the municipality orders you to tie into your sewer system. You don't really have a choice not to tie into your sewer system. But the fees, and actually the Municipality Authorities Act is very specific about this. Fees for sewer systems have to be tied very specifically to the costs associated with to the municipality. And there's very specific rules on how they can charge tapping fees and then other types of annual fees. So I think that there are specific rules. I think that there's actually a more, I think the argument would be at least that there's a more discrete benefit being provided in the context of a sewer system than what the Commonwealth Court found, at least in this case, in a stormwater system.
Thank you so much for that. And I also encourage anybody to follow up with Mark or us outside of this session. So the next question is, given this decision, has anyone heard if PADEP would consider relaxing their MS4 permit or PRP deadlines for all Commonwealth municipalities? Given this decision, pardon me.
I have not heard, and I would be surprised if they did. They've had these requirements in place. The vast majority, I mean, virtually, well, the vast majority of municipalities that are subject to the MS4 requirements don't have fees. So it's not like for a lot of them, the fees going away. I will tell you a lot of municipalities, including the municipality where I'm a supervisor and some where I'm a solicitor, have been working on fees and did intend to implement fees and are still intending to implement fees in one form or another prior to this decision coming down. So this is clearly having a ripple effect on the municipalities. But the MS4 program is really driven by the Clean Water Act. As I mentioned, it's being driven by regulations. It would be nice if they were going to. I would be, and I don't know if they are or not. I would be surprised if they're going to.
Thank you. And the next question says, do you envision the Pennsylvania Green Amendment playing into this issue in the future? It seems like impervious surfaces affect multiple public natural resources, including soils, groundwater, and surface waters.
It's a very interesting question. It's actually something I'll admit I have not given a lot of thought to, which might be quite to the chagrin of Delaware Riverkeeper and Shari and Maya. But I'm glad you raised the question. I am going to give it some thought. I'll try and do it on the fly off the top of my head. I do think stormwater impacts. Well, the environmental amendment basically deals with natural resources, and obviously the impact on natural resources. You know what? I'd have to think about it. That's a good question. I really don't have an answer for you. I apologize, but I appreciate the question, and it is something I'm going to give some thought to.
Thank you so much, Mark. Are there any other questions from the audience? Those were all that were in the chat. I'll give it another minute or two if you want to. Lovely. So we have one more that just came in. So this question says, it seems as though a properly designed charge taking into account all the issues you raise would stand a good chance of holding up as a fee. Do you agree?
It's hard. I mean, it's really hard to know, right? Because we don't really know. The only thing we know from, and frankly, we have, some would argue we have two competing recent Commonwealth Court cases, one calling it a fee, one calling it a tax. We don't really know. I think, what I can tell you what Commonwealth Court said in the most recent case is that they felt that the court, that the borough had not met its burden of showing the benefits. So I do think that if they were able to establish that there were benefits, it might stand a better chance. And I also, as I mentioned, maybe particularly under a different statutory scheme, it might stand a chance. But you could read the Commonwealth Court decision to sort of imply, well, there really aren't benefits. This really is a benefit to the general public, not a discrete benefit. But I think the court, because they just didn't have the evidence, what courts, they don't like to issue what's called dicta. They don't like to surmise. So they essentially said, well, the borough hadn't made the showing. But I think it's an open question whether they could have made the showing in any event. I will note that the Commonwealth Court did specifically note the issue of not having statistics on the amount of runoff that was coming off of the property due to impervious surface. Whether that would have made a difference or not, I don't know. I will note that interestingly, in my experience, even when you're dealing with sewer flows, oftentimes you're not actually even measuring the sewer flows in that situation. You're using the water usage as sort of a surrogate estimate for the sewer flows to determine how much sewer flows you have. Although, more and more now you're starting to see, sewer meters being put in place.
So probably the last question for our session today. With the Commonwealth decision, it appears that Westchester Borough could have taken the drainage area feeding into the Westchester Borough stormwater system from the university property to determine flows and volumes and/or pollutants from stormwater runoff that are flowing into the system and impacting it. But it will require engineering calculations and monitoring. Is this true?
I think, I don't know how they would have done it. I mean, I will say that one of the things the court noted is that they didn't make a showing that impervious surface increases stormwater. Now, at least in this context, that at least the borough has to then treat. I found that to be a curious finding. I think most of us tend to think of impervious surface, if it's true impervious surface, as increasing stormwater flows. I think from an engineering perspective, and I would expect, I will tell you, I'm just coming off a stormwater trial in Williamsport, and last week was the last days of the trial, and that was sort of, our experts were, sort of testifying. That didn't even seem to be in dispute. It was a question raised, so I think there might be ways of measuring it. I think the question is the court willing to say that that's enough? I will also note that in Pennsylvania, and this is a case that came up, this is a situation that came up in the Virginia case that dealt with rail yards. There's some, Pennsylvania and a lot of states, define impervious surface in a certain way. It's not necessarily concrete asphalt. It can be, stoned, compacted stone roads, which, might have a little bit better infiltration than asphalt. So, what is impervious is a bit of a legal definition as opposed to just a practical definition. So you would also have to look at how impervious surface is being defined.
Thank you so much. And our final question is, what conclusions do you draw from your inability to determine whether an appeal has been filed, although the deadline has passed?
I'm not, I mean, I would, it's a good question. I mean, I may have just missed it, and that's why I wanted to be upfront with the fact that I just hadn't. I looked at the Supreme Court dockets. I didn't see it. I may have missed it. I looked at, I put it through, we use Westlaw. Normally when there's something filed on a subsequent case, it shows up in the case history. I didn't see it. I would find it surprising that if the appeal is not filed, but it's possible that perhaps the borough has decided not to pursue it. I just don't know. I will tell you that one thing. So this was originally issued as an unreported decision, which the rules have changed a little bit recently, but generally it can carry less weight in subsequent cases if it's unreported. There was a petition made to issue it as a reported decision, and in checking the dockets, I did see that Commonwealth Court did grant that petition, so it is going to be a reported decision and carry the weight of a reported Commonwealth Court decision.
Well, thank you so much. I'm afraid it's time to wrap up our session, but I want to thank our speaker, Mark Alfred, once again for taking the time to share his expertise with us. Thank you so much for joining us, and we hope to see you in 2024 in Pottstown, either in person or virtually. Have a wonderful day, everybody.